Hello aspirants, so we are here with GS paper 2 and we'll make a discussion of GS paper 2 not in very detail, but then we'll talk in terms of whether the paper was difficult in comparison to 2024, and also we'll talk about the distributions of marks, how the marks has been distributed among the various topics, and then we'll go into GS paper 2 2025 mains and we'll make a brief discussion of all the 20 questions. So let's get started. So we'll start with the distributions of topic. So if we have to compare in terms of difficulty level, the difficulty level of 2025 mains GS paper 2 is comparatively similar kind of difficulty if we have to compare from 2024. The difficulty level is somewhat similar, and since GS paper 2 is dynamic, some dynamic questions has been asked from the polity aspect, also from the governance aspect, social justice, and of course the IR is always dynamic. So the difficulty level is not much different in comparison to the previous year. It is somewhat similar, and anybody who has prepared well, they will find the question as normal as it is almost every year. So let's look into the, having talked about the difficulty level, which I have already mentioned that it is similar to 2024, not much difficult or not much easier in comparison to 2024. Now let's look into the distribution of marks. If we look at the distribution of marks, they are also kind of similar only in comparison to 2024. So the questions from will divide into 4 topics here: polity, social justice, governance, and IR. So polity, they had asked 9 questions. 9 questions on polity, 110 marks. 110 marks from polity. That is what I am talking about 2025 mains. That is what I am talking about. That is what I am talking about 2025 mains. And here we'll talk about 2024 mains. So we are making some comparison in terms of distribution of topic. So 9 questions from polity, from social justice, the 4 questions they had asked. 4 questions on social justice, 50 marks. 50 marks. And governance, there is 3 questions on governance, 40 marks. And 4 questions from IR, that is 55 marks. So this is what about the distribution of marks among the various topics. And if we have to see from, compare from 2024, polity 10 questions. Last time they asked 10 questions on polity, 125 marks. 125 marks on polity. Social justice, they had asked 4 questions, 50 marks. Then governance, 2 questions, that is 25 marks. 25 marks. And IR again 4 questions they had asked last year also, 55 marks. 55 marks. So in terms of distribution, it is again almost similar to 2024, except that 1 extra question they had asked in polity. This year 9 and last year it was 10, and 1 question they have deducted in governance. Last time it was 3, this time it is 2. Otherwise, social justice and IR, it is again a similar kind of distributions. So not much different from 2024 in terms of difficulty level and also in terms of distribution of marks among the various topics. So now let's look into 2025 paper. We'll make a brief discussion of all the 20 questions. We'll see how we could have approached all the questions. So let's see. So let's see the first question. Discuss the corrupt practices for the purpose of Representation of People Act 1951. So they are asked the question from RPA. RPA has been becoming popular. Of course, this year a lot of issues of malpractices and electoral fraud issues has been coming in news. Whether they are properly verifiable or not, that we have to see, but yes, it has made news. It has made news regarding the electoral malpractices. So in this context, this question was very much expected about RPA. Discuss the corrupt practices. So look at the question. So first of all, we need to understand the meaning of the question. They had asked particularly about the corrupt practices. पेन का देखो. All right. Fine. 1 minute. Not bad. Increase the size. It's okay. Yeah. So look at the first question. Discuss the corrupt practices for the purpose of RPA 1951. Analyze whether the increase in the assets of the legislators and or their associates disproportionate to their known sources of income would constitute undue influence and consequently a corrupt practices. So it's very important that you understand the meaning of the question. They are asking, first thing they are asking about what is corrupt practices under Representation of People Act 1951. That is the first part of the question you have to talk about. And then they are asking, analyze whether increase in disproportionate assets that would amount to undue influence and hence consequently a corrupt practices. So there are two parts of the question. The question is little tricky because here one thing they are asking about what is corrupt practices under Representation of People Act. The definition you must know. Secondly, they are asking whether the increase in asset or disproportionate asset that would amount to undue influence. So you should also know what is undue influence and whether that would amount to corrupt practices under RPA 1951. So that is what you have to talk about. So the first part of the question, you please define what is corrupt practices under RPA 1951. So that has been mentioned, like taking bribes or bribing the voters, using instigating religious sentiments, or garnering vote on the ground of religion or caste, or creating any kind of hatredness, that is hate speech. All these things will come under the corrupt practices. That you must know, that what is corrupt practices under RPA 1951. That the first part of the topic is done. And then you talk about what is undue influence. Undue influence under 1951, that is RPA 1951. So in this context, you talk about undue influence, even if you don't know the exact definition or so, but you will definitely able to understand the meaning. What is undue influence? Any influence, either direct or indirect, that is going to somewhere obstructing the free and fair election, isn't it? The objective of RPA 1951 is what? So there should be free and fair election, isn't it? The electoral process should be free and fair. That is what. So undue influence is any influence, either direct or indirect, that is creating an obstacle in conducting an free and fair election. That is called undue influence, right? Bribing the voters, or creating any kind of threatening the voter, creating any kind of pressure on the voters to vote in certain manner. These are called undue influences, right? So that you must talk about the undue influences. Then the second part of the topic, that is the second part of the questions, that is saying that whether increase in the assets or disproportionate assets. Of course, when somebody have a disproportionate asset. Now, disproportionate asset, that amounts to corruption under Prevention of Corruption Act. Because see, RPA 1951, that deals with the elections. Once they get elected, once the contestant, they got elected, and after that, if they are indulging in any corrupt practices and they are amassing lot of wealth, they are amassing lot of or disproportionate asset, then they will come under what? They will be scrutinized by the public agencies like Enforcement Directorate. You must have heard in the news, lot of in the news, like Enforcement Directorate is raiding so and so ministers and has found disproportionate asset and so, a lot of in news you would have found. And this was in lot of news, the issues of Enforcement Directorate and the political leaders having, they have amassed wealth beyond their known source of income. There was a lot of news, and the issues of malpractices in election, that was also in news. So obviously this kind of question was much expected, but they have clubbed both the issues. They have clubbed one regarding the before entry into the election, and once they get elected, what are the corrupt practices. Both they have merged. That is what we have to be very careful about. So one, we have to talk about RPA 1951. Under that, what is corrupt practices, and then what is corrupt practices under Prevention of Corruption Act. That is when they become public servant. The legislator, they also come under the meaning of public servant, right? So that is what we have to talk about, that disproportionate assets and all after becoming a legislator or so, that would amount to corruption under Prevention of Corruption Act 1980. And for this, the public agencies like Enforcement Directorate, they will scrutinize. Now, having talked about these two issues, then you talk about, the question is talking about whether amassing wealth beyond known source of income would amount to corrupt practices, or what they are saying, would constitute undue influence. Now, if the legislator, they have got so much of wealth and they are again, contesting the elections or, supporting their associates, and when they are using those money which they have got from the corrupt means, that money if they are using to create undue influence during the voting, then it will be called as corrupt practices under RPA 1951. So be careful, this question is bit tricky. This question is a bit tricky. So just because they have amassed so much of wealth, that does not mean undue influence in itself. Yes, I have, see, a legislator has got a lot of wealth beyond the known source of income. That mostly they try to utilize to create an undue influence in the next elections or supporting their kith and kin in the elections. They may use that money to go for undue influence, they may not also. So if they use their money to create undue influence, then it will amount to corrupt practices under RPA 1951. If they don't utilize money to create undue influence, then it will be not called as corrupt practices under RPA 1951. It will be called as corruption under Prevention of Corruption Act 1988. Prevention of Corruption Act 1988. Okay, I hope you got the clarity. The question is bit tricky and you have to identify that trickiness and then you have to go. So first you talk about what is corrupt practices under RPA 1951. Secondly, you talk about what is undue influence under RPA 1951, and then you talk about the disproportionate asset, and that will be scrutinized by the public agencies which comes under the Prevention of Corruption Act 1988, right? So here it is about two things, RPA 1951 and your PCA 1988, okay? And then they are asking whether the money they have got would constitute to undue influence. Not necessarily. If I have so much of wealth and I have acquired through unfair means or through corrupt practices, I may utilize that money for undue influence, I may not. If I utilize my corrupt money or the money I have got through corruption or disproportionate asset to create an undue influence in the election, then it would amount to corrupt practices under RPA 1951. Otherwise not. If I don't utilize that money to create any undue influence, that won't amount to corrupt practices under 1951. It would amount corrupt practices under what? PCA, Prevention of Corruption Act 1988, right? I hope I made it very, very clear here. I hope you are able to understand what I am trying to make you explain here or make you understand here. So this questions is little bit tricky. You have to utilize both Prevention of Corruption Act and RPA 1951. So moving on to the next question. Moving on to the next question. Number 2. Comment on the need of administrative tribunals as compared to the court system. Assess the impact of recent tribunal reforms through rationalization of tribunals made in 2021. So they are asking the issues which happened in 2021, but then again I hope if you could relate, the question is easy. The question is easy. So first part of the question, they are talking about the need of administrative tribunals. So please talk about the need of administrative tribunals, that why the administrative tribunals, and please talk about the constitutional provisions, constitutional provision article 323A, right? And you talk about it was included in 42nd Amendment Act, all these things you can talk about. Created in 1985, these are the various factual informations, and then you talk about why it is required, so that because of speediness, it gives a speedy justice, it is more accessible, it deburdens the regular court, and also where expertise is required in dealing with certain issues which the court might not be in such a position to deal with such kind of expertise situations. In such case, the administrative tribunals or the various types of tribunals, not only administrative tribunal, but there are various other types of tribunals, they are required to make the justice speedy, affordable, accessible, and also where expert judgment is required. Because of these reasons, the administrative tribunals are required. Then now they are talking about the second part of the topic. They are talking about the recent tribunal reforms through rationalization of tribunals in 2021. Now in this case, you have to talk about the Supreme Court judgment. So earlier, the appeal from administrative tribunals directly used to go to the Supreme Court. But later on, the Supreme Court in the L. Chandra Kumar case, Supreme Court told that the appeal from the administrative tribunal should go to the High Court first, and then it can come to the Supreme Court, but not directly to the Supreme Court, or not bypass the High Court. They should go first to the High Court. So after this, what happened? The tribunal started losing its appeal, because anyway, if it has to go to the High Court and then again to the Supreme Court, better, many tribunals or the authority thought that let it directly go to the High Court. What is the use of then administrative tribunals if we have to go with the two layers of appeal? So because of that, after this judgment, the authority, what they have done, they have scrapped many state administrative tribunals has been scrapped. Many state administrative tribunals has been scrapped because of that. So that is what you have to talk about, rationalization of tribunals. I hope you got the clarity, and then you can conclude that administrative tribunals, by emphasizing on its need, that scrapping of administrative tribunals may not be a proper thing, because the administrative tribunals or the various types of other tribunals were set up with certain objectives to deburden the courts, to provide speedy, inexpensive justice, and also where expertise is required. So such kind of things, even now it is required, isn't it? Even now it is required, even if, okay, fine, the Supreme Court judgment says that first appeal should go to the High Court. In spite of that, the relevance of the administrative tribunal is very much there, and that is how the both pros and cons should be weighed before rationalizing of the administrative tribunals. Okay, fine. So I hope you got an idea regarding the second number questions. Now let's look into the third number question. Third number of question. So third number saying that compare and contrast the president's power to pardon in India and US. So are there any limits to it in both the countries? What are the preemptive pardon? Preemptive pardon. So you see, they are asking here. So the question is again, if you can analyze, it is, you can write good answers. But if someone find that, what is the way to pardon in US, they might find it a bit difficult. But then if you can somewhere relate the things, definitely the executive power in US is high in comparison to India. The president is in India, where the president of India is a nominal executive, but the president in US is the real executive. So obviously there will be the differences, right? There will be the differences. So here you talk about, you can compare and contrast. Article 72 you talk about, and the president in India, president of India, they can pardon the sentence of death, court martial, or any offences against the union government, right? That you talk about, Article 72. And then you talk about that the president of India, they take the decision on the advice of council of minister, not alone, because in India the president is the nominal executive. Now come to the US and talk about the US. The president, they take their own decision, right? Own decision, because he is the real executive. He is the real executive, unlike the president of India, who is the nominal or ceremonial executive. So that is one point of difference you can certainly talk about. So there he need not consult his secretary. He can there is no binding. Even if he consult the secretary, it is the president on his own, he can take the decision. But such things are not there in India. The president is bound by the advice of council of minister, isn't it? So here you can write Article 72, and then you can write about Article 74 as well, aid and advice of council of minister. And here you can talk about that he is the real executive and he can do its own, Are there any limits to it in both the countries? So limitations, so we have talked that in the president, he can take the decision on the basis of advice of council of minister. Article 74 you have to talk about. Whereas in president of US, he can take his own decision, right? Then you talk about what is preemptive pardon. Now, preemptive pardon. In India, the pardon happens once the person is convicted, right? The person is convicted. Then the issues come as a mercy petition to the president of India. It is not preemptive. So first the court has to, give the judgment, and the proper trial will happen and the judgment will come. The person is convicted, and then he can file a mercy petition. So there is no preemptive pardon in India. There is no preemptive pardon. Preemptive means before the trial, before the conviction or before the trial, or before the conviction. Whereas in US, there is preemptive trial. Where is preemptive trial? So before the case goes to the Supreme Court or to the judiciary, the president has power for preemptive pardon before the trial itself, before the conviction itself in US. Now this piece of information, many students, they might not know. They might not know that whether in US such things are there or not. Okay, fine, this point many people, they might not know, many candidates might not know, but then rest of the answer, I think you will be able to write, isn't it? It's not that difficult. If little analysis you could do, you can write still a good answer. I hope you got the clarity. So you have to talk about, compare and contrast the president power to pardon in India and in US. Are there any limits? We have talked about in India, it is on the advice of council of minister, and also if you have to talk about one more thing in the limit, you can talk about that there could be judicial review. There could be judicial review in case of there is a malified intention. Supreme Court has already told that there would be judicial review if the pardon is done on the basis of any malified intention. But such things are not there in US. That is what you can talk about. And the third aspect, that is about the preemptive pardon. In India, there is no preemptive pardon. First of all, you should know what is preemptive pardon. That is before the case it is tried or before there is a conviction, the president can pardon or not. In India, it cannot be. In US, it can be. I hope you got the clarity. Yes. Question number 3. Now let's move to question number 4. Question number 4. Discuss the nature of Jammu and Kashmir Legislative Assembly after Jammu and Kashmir Reorganization Act 2019. Briefly describe the powers and function of the Assembly of the Union Territory of Jammu and Kashmir. Now this question, again, you know, you can relate with that since 2019, after the reorganization, what has happened? The Jammu and Kashmir has lost the full-fledged status of statehood, and now it has been converted into union territories with legislature, Jammu and Kashmir, and Ladakh with no legislature, right? Ladakh with no legislature. So anyway, it is talking about Jammu and Kashmir, so you talk about. Now there is a similar power what the Delhi and Puducherry has. Delhi and Puducherry has. Even the Delhi and Puducherry also, you know, there is an, these are the union territories with legislative assembly. So in that context you can write about, easily you can write about. So they have the legislature has the same power as any of the state, or you know, they can make lists, they can make policies or laws which is mentioned in the state list, except two things, that is public order and you have the police and land. So this aspect they cannot make the law, where the union will make the law. Otherwise, they can make the laws on all the aspect of state list and concurrent list. So that is what you have to relate and write. I think the question is easy. The question is easy. The next question, number 5. The question is about the Attorney General. So, Attorney General of India plays a crucial role in guiding the legal framework of Union government and ensuring sound governance through legal counsel. Discuss his responsibilities, rights and limitation in this regard. So, again, you know, this question, Attorney General, I have already discussed when we were doing the UPSC mains, probable mains question. In that I have talked about Article 143, that you know, the presidential reference. So they have not given directly in that manner, but somewhere I can say that it is related. So because one of the function of Attorney General is also related to Article 143, we'll talk about. So Attorney General, you talk about Article 76, right? He is the law officer of the government, of India, provided legal advice to the government of India. It also represents the government of India in front of Supreme Court or High Court in legal matters. It defends the government of India and provided legal advice to the government of India, defends the government in front of Supreme Court and High Court, right? Then these are the responsibilities of the Attorney General of India. Now what are the rights? So under the rights you can talk about the Attorney General of India. They can have audience in any court, they can have audience in any court, they can also have audience in parliamentary proceedings, they can be the part of the parliamentary proceedings in both the house of the parliament, of course without right to vote, that you can mention about its rights. And then it is limitation. What is the limitations? So limitation of Attorney General of India, that you can talk about, that they do not have the security of tenure. They are being appointed by the President of India and they remain in office during the pleasure of the President. They remain in office during the pleasure of the President. So there is no security of tenure. There is no such, there could be arbitrary removal. So those are, you can talk about the limitation, and also you can talk about that his advice is advisory in nature. Advisory, isn't it? It is not legally binding on the government of India, whatever he talk about or he advises. So it is advisory. Advice means advisory, right? So those things you can talk about the limitation. One, his advice is non-binding. Secondly, there is no security of tenure, and he remains in office during the pleasure of the President. That is what you can talk about. I think it is easy, very easy, direct, very direct and easy questions. Next question, question number 6. Women's social capital complements in advancing empowerment and gender equity. Now this question, that is bit analytical, you have to analyze, and then first of all you have to understand the meaning of social capital. What do you mean by social capital? So social capital is building relationship, networking, garnering support, isn't it? Social capital. You have a networking, you have relationship, you have a supportive relations, support. So definitely a person who has all these kind of things, they feel more empowered, isn't it? They are more empowered. Imagine if the person has no support, no relationship, no networking, they feel helpless, isn't it? So particularly it is related to women. So the women are the vulnerable section of the society. They are being treated as the vulnerable section of the society, disadvantaged section. So particularly the women, if they need to be empowered, they need to build social relationship, they need to build networking. Apart from the capacity building, of course they need to build their capacity through proper educations and building on their skills. At the same time, they need to build the social relationship, networking, supportive relationship, which will help them in empowerment and gender equity. Because in India there is a patriarchal society where women are certainly at the disadvantaged section. They have to build more of their strength to overcome such kind of patriarchal norms or limitation, and in that building social networking, social capital is certainly going to help them out. So that is what, this is how you can approach this question. The next question, number 7, e-governance projects have built-in bias towards the technology and back-end integration than user-centric design. I think again this question is also quite straightforward, easy, very, very simple. So you talk about the e-governance, why e-governance is required to improve the efficiency, transparency and accountability of the administrative system, and also to make the system more responsive, isn't it? More responsive, more participatory, to make the administration more responsive, more participatory. Technological solution is very, very important, or e-governance is very, very important. You can give some example how e-governance has helped in increasing efficiency and also making it more participatory and easier for the people, But then it is talking about built-in bias. So how it is bias? It is bias because you can give some data and all, how the internet penetration in India is, internet penetration, because for e-governance you need internet access. So talk about internet penetration, talk about digital literacy, because that is again very low. Then digital interface, digital interface, the language used, which many people they don't understand, right? It is primarily in English. So obviously all this thing create a biasness, digital divide, isn't it? Who will get benefit from the e-governance project? Those who are what? Those who are digitally literate, isn't it? Digitally literate, and those who have access to technology, internet and so, isn't it? So obviously those who do not have, or those who comes under the second part, or those who face the barrier of digital divide, and there are huge number of population. In fact, majority of the populations, they don't have internet access, or they are digitally illiterate, and there is also an issue of the language used, the digital interface which is not consumer friendly or citizens friendly, because most of in India still they are digitally illiterate, right? Then having talked about the problems, you can talk about the solution, isn't it? So reverse the problem, you get the solution. So in that you can talk about how to make it more user friendly. So increase digital literacy, increase in penetration of internet, make it user friendly interface, use of multilingual, so and so. So I hope the questions is very easy and direct. Moving on to the next question. 7 we did. Number 8. Question number 8. Civil society organizations are often perceived as being anti-state actor. Civil society organizations often perceived as anti-state actors than non-state actors. So again, this question also simple, I guess. So you talk about civil society organization. Here they are talking about anti-state. What do you mean by anti-state actor? And then what do we mean by non-state actor? Non-state actor. So they are more treated like anti-state actor rather than non-state actor. Who? The civil society organization. So who are the civil society organization? You talk about, define the civil society organization. And why are they called non-state actor? Because those organizations which are not either directly part of the government or not recognized by the government, they are called as the non-state actor. Non-state actor doesn't mean they will always be illegal, isn't it? So civil society, they basically they are the bridge. They are the bridge between citizens and government. They act as a bridge. Who are the part of civil society organization? Your NGOs, self-help groups, community organizations, isn't it? Pressure groups, all these are part of your civil society organization, and they are like a bridge between the government and the citizens. They act as a bridge, and they are the non-state actor because they are not the part of the government, right? Now they are saying that their civil society organization, they are more treated as an anti-state actor rather than non-state actor. So we have seen, like in many cases you can quote numerous example where the NGOs, like the Greenpeace and all we have heard about, where if they talk about anything about development or if they talk about wrong policies of the government, they are being branded as anti-national rather than anti-government. They are being branded as anti-national. There are a lot of examples you can quote about. And And this reflect a very sorry state of affair, very sorry state of affair, because anything which is being treated as or going against the government, they are being treated as anti-national. So in a democracy, people have right to dissent, isn't it? People have right to dissent against the government policies or so. That doesn't mean they are anti-state. So that is what we have to talk about, that there have been many NGOs and groups, civil society organization, which were being treated as anti-national just because they have criticized government policies or so. And that is not a very happy state of affair. In a democracy, such kind of things is totally, they should be unwelcomed. And what for the vital functioning of democracy, for the vital functioning of democracy, it is very, very important that the civil society organizations, they are allowed to operate in a free manner, right, without any kind of restrictions or without any kind of threat to being branded as anti-state, right? They should be given freedom to operate because they are the bridge between citizens and state. They make the state accountable. They raises the voices against the state if the state is not functioning in a democratic manner or the state is adopting any anti-people policies. So civil society organizations, they are very, very important, and in that way I think you can write about. I hope you got the idea how to approach this question. Civil society organizations are often perceived as being anti-state actor rather than non-state actor. So you talk about civil society organization, why are they non-state actor, and then why are they being branded as anti-state actor, and then you give some example, and then you in the conclusion you can talk about that this kind of system, it is totally against, it is very much threat against democracy if such kind of things are there, because the civil society organization, they are very, very important and eminent for the vital functioning of democracy or protecting citizens' rights. Then next question, you see number 9. India-Africa digital partnership is achieving mutual respect, co-development and long-term institutional partnership. So in this you can talk about the India-Africa relationship. It is of mutuality, mutual interest, unlike the China factor, because here you see they are achieving mutual respect. We are not dominating. So whereas Africa provide us with the vast market and so, and there is India using its low cost technological development in kind of exporting to Africa and helping them out, developing them. Our aim is to develop Africa, not to subjugate or not to make them in a debt trapped kind of things. Unlike what China being criticized of debt trap, we are here for mutual respect and co-development. We are here for the co-development. The benefit should be shared for both, whereas India gets the market and African, they get the technology, right? So it is for win-win situation. It's an opportunity for both. That is what you can talk about, and in that you can talk about tele-education in which we have e-Vidya, which has been turned, then e-Arogya, that is telemedicines, tele-education, that is what you can talk about. I hope you got the clarity. Again, it's very simple, very easy, and a little bit you can put it the China factor here and how we are different. Our model of development or engagement with Africa is different from that of China. Little bit you can mention to emphasize that India believes in mutual respect and co-development rather than making them in a kind of patronage. We are not patronizing them, but we are helping them and as an equal partner, The next question, you see. The next question, number 10. With the waning of globalization, post-Cold War world is becoming a site of sovereign nationalism? Now, this is a very interesting question, I can say, where we are talking more about globalization, but this question is talking about anti-globalization, or the globalization is waning down or it is reducing. That is what it is, right? Waning of globalization or reduction in globalization. So here you can talk about how globalization is reducing. So after the Cold War or disintegration of Russia, the globalization took pace, particularly after the 1990s, right? We opened up the economy and there was integration of the economy, there was interdependency, isn't it? There was interdependency, there was integration of the economy. But then particularly after 2008, if you remember, when the recession came and people found that, or the nations found that there is a lot of negative outcome of globalization, because too much of integration has resulted in catastrophic spread. Particularly you have seen the subprime crisis in US, how it spread to the European countries, particularly the European countries, because they had more interaction with US. So there was a bad effect of globalization. There was a bad effect or catastrophic effect of globalization spreading to the countries which are more integrated among each. So there was a kind of an during that time there was a kind of a criticism of globalization, because the globalization was more for the beneficial of, you can say, westernization, particularly the US economy has more benefited than any other economy because of the globalization. But 2008 you can talk about, and that COVID-19 also you can talk about. All these things helped us to realize that self-reliance is very, very important, because COVID-19 and 2008 crisis that had shown that too much of interdependency could create a lot of problem rather than benefit. It could create a lot of problems, and there is a breakdown of supply chain. There is a breakdown, particularly you see Ukraine war, and the breakdown of supply chains. All this thing has made us the world know the benefit of sovereign nationalism or self-reliance. So in this we can talk about Atmanirbhar India, is it Atmanirbhar Bharat? We are talking about self-reliance. So that is what called sovereign nationalism. So this is how I think you can, so this question is little tricky, I can say little tricky, but if you understand what is the meaning, how globalization is waning down and how we are more moving towards sovereign nationalism or towards self-reliance, and in that context you can talk about Make in India or Atmanirbhar Bharat. Then let's talk about the next question, number 11, constitutional morality. Now this topic is, again repeated, I can say, because earlier also they had asked on the constitutional morality. Yes, the context could be different here. Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. So fulcrum means what? Seesaw balance. So that the middle part, that is called fulcrum, isn't it? It tries to balance. So constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. So you see, you should have a good vocabulary. Certainly you should understand the meaning of the word. So if somebody, they're weak in so, they'll find it a bit difficult. But then anyway, somebody reaching to the level of writing mains, I think they should be in a position to understand the questions. So read the question very carefully, and Constitutional morality is the fulcrum which acts as an essential check upon the high functionaries and citizens alike. So what, and in the view of the above observation of the Supreme Court, explain the concept of constitutional morality. You have to explain, and its application to ensure the balance between judicial independence and judicial accountability. Now this question is, first of all you have to define what is constitutional morality, and then you have to apply on what particularly the topic talks about, the question talks about on judicial independence and accountability, right? Seesaw balance, and the fulcrum is the middle one which try to balance it. So talk about the constitutional morality. What is defined constitutional moralities? So there's the values, principles, and the spirit of the, it is the adherence to the values, principles, and spirit of the constitution, that is called as constitutional morality. And this concept was being brought by the judiciary, particularly in the Naptej. You can talk about Naptej Johar case, 2018, and then in the Sabrimala case also, the judiciary talked about the constitutional morality, that we need to adhere to the values, principle, and spirit of the constitution. That is called constitutional morality. All the functionaries, all the higher functionary persons with authority, they should adhere to the constitutional morality. That is what you talk about. You can give some case also related to constitutional morality where the Supreme Court has talked about. And then you talk about here, the second part of the question is about the application to the judicial independence and judicial accountability. So what is judicial independence and judicial accountability? So you talk about the judicial independence, which is again, you know, the power of it is a part of basic structure. The judiciary in the various cases has talked about the judicial independence is a part of basic doctrine which cannot be taken away even by the executive or legislature, and that is very, very important for the vital functioning of democracy and protecting citizens' rights. Judicial independence is very important. Then the second part, they are talking about the judicial accountability. Now judicial independence is important, but at the same time judicial accountability is also important, isn't it? So there has been issues and cases where the judicial accountability has been questioned, particularly in the use of judicial review, particularly you can talk the contempt power or contempt of court case, article 129. These issues, there has been issues even in terms of appointment of judges. There has been issues of judicial transparency or accountability where there was certain kind of allegations or so that the judiciary is not performing in an accountable manner or in a transparent manner. So you can talk about one, the use of contempt power, article 129, use of judicial review. There has been also allegations from the executive and legislature that there has been the arbitrary use of judicial review. And then you can talk about appointment, that is the collegium system. That collegium system is also not functioning up to the mark. There has been opacity in the appointment procedure. So through all these things, the judiciary feels that they are above accountability, or they have made in such a manner that the accountability is not so much enforced by the judiciary. In case of judiciary, as it is enforced for the executive and legislature, there is somewhere perception, or it seems like the judiciary is above accountability. So that is what you have to talk about, that constitutional morality not only applies for the functioning of executive and legislature, but also for the judiciary. Judiciary should also make them accountable in the same manner as they make the executive and legislature accountable, right? So that is what you can talk about, and some cases, you know, you can talk about here in the contempt of court case, or collegium case, NJAC. NJAC also you can talk about, striking down of NJAC. So these things, it is perceived that the judiciary is shielding itself so much against accountability. Interesting question, isn't it? Constitutional morality and then application, particular application on judicial independence and judicial accountability. Then let's look at the question number 12. Question number 12. Indian Constitution has conferred the amending power on the ordinary legislative institutions with a few procedural hurdles. With a few procedural hurdles. In view of this statement, examine the procedural and substantive limitation on the amending power of the Parliament to change the Constitution. So here they are talking, one about the procedural limitation and secondly substantive limitation. So you should know what is substantive limitation. So Indian Constitution, you talk at the first part is I think very easy. Article 368 you talk about, where the Indian Constitutions has been given the Parliament has been given the amending for the Constitution. And in this context, so Indian Constitution has conferred the amending power on the ordinary legislative institutions. Ordinary legislative institution means the amendment of the Constitution is in the similar manner as the ordinary legislation takes place, isn't it? It is not like you have to create a separate constituent assembly as it happens in the America for amendment. So our amendment system is much more flexible and easy. It is done in the same manner as that of the ordinary legislation, except that there are certain procedure you have to follow, which is mentioned under Article 368, that only the amendment should be brought only in the Parliament, isn't it? Only Parliament can bring the amendment bill, not the state. Secondly, it has to be passed with higher majority, 2/3 majority, and if the federal issues are involved, 2/3 majority in the Parliament plus half of the state, they should ratify it. And then another procedural formality is that the President should sign the amendment bill. He cannot ask for the reconsideration. He has to sign or he has to give assent to the constitutional amendment bill. So these are about the procedural factors you talk about. Then the second thing they are asking about substantive limitation. What are the procedural factors? And then substantive limitation. What are the substantive limitations? So these are the, you can say, procedural limitations, or even in the sense that it can be brought only in the Parliament, not in the state legislature. One. Secondly, higher majority is required, not simple majority, isn't it? Like ordinary bills, they can be passed with simple majority, but here higher majority is required, 2/3 majority. And again, where the federal issues are coming, higher majority, that is 2/3 majority, and again half of the state has to ratify it. Then the President must sign the constitutional amendment bill. So these are the procedural aspect. Then substantive limitation. What are the substantive limitation? Here you can talk about the judicial intervention. Judicial intervention. In this you can talk about, there is judicial review. Judicial review. First of all, you can talk about the Parliament cannot amend basic structure of the Constitution. That is substantive limitation. Can amend any part of the Constitution, but not the basic structure of the Constitution, and that is very substantive limitation. So that you talk about basic structure cannot be amended, there is a system of judicial review. If the judiciary feel that the basic structure or the amendments is going against the constitution, the amendment which has been brought by the parliament, it is in any way against the constitutional norms, or they are ultra vires the constitution, so in that case also it can be struck down, right? And secondly, if it is against the basic structure also, it can be struck down. And you know what is basic structure, what the judiciary has, you know, illustrated. There is nowhere it is something which is written. So these are the substantive limitation on the power of the parliament to amend. They can amend any aspect of the constitution, but then there are certain limitation brought by the judicial review, that it should not be against the constitution. Secondly, it should not be against the basic doctrine of the constitution. It should not amend any basic structure of the constitution. I hope you got the clarity. That is what about the procedural and substantive limitation. Next question, moving on to the next question. Let's see, question number 13. Again, you know, this collegium system, I guess earlier they had asked, so again that's very easy. Discuss the evolution of collegium system in India. Critically examine the advantage and disadvantage of the system of appointment of judges of Supreme Court of India and US. Here little comparison they have done, India and US. So the first part of the question, you talk about the evolution of the collegium system. The first judge case and second and third you briefly talk about. Regarding the appointment of judges of Supreme Court, Article 124 and 217, that is what you can talk about under that. And the various judges, first judge, second judge and third judge case. And then you can write the fourth judge case also, in which the judiciary strike down NJAC, National Judicial Accountability Act, was strike down by the judiciary. That also you talk about, because that also related with the appointment of judges. So all the four case you mentioned, that is because they had asked about the evolution, so talk about that. Then critically examine the advantage and disadvantage of appointment. So advantage of collegium system. What are the advantage? Judicial independence, isn't it? There is no political interference, because we have seen how the judges were being appointed during emergency. The seniority principle was not followed and there was more political appointment. So we have already seen during the emergency how there was interference in the appointment, executive interference in the appointment of judges. And because of doing away all those political interference, these various judges, under the various judges case, the collegium system evolved to protect what? Judicial independence. That is what you talk about. Then what is the disadvantage? The disadvantage is that there is a opacity. There has been concerns that the collegium system is functioning in an opaque manner, and there is no particular criteria how the judges are being appointed. There is no open criteria which is being followed. So all this thing has gone against the judicial appointment, or there has been a concern, serious concern regarding the opacity in the appointment by the collegium. So that you talk about advantage and disadvantage. And then you talk about how they are different in India and US. So India, you know, there is the collegium system for the appointment of judges of Supreme Court and High Court. In US, it is what? It is the president. There is no collegium system as such. It is the president who appoints the judges of Supreme Court there in consultation or by ratification of the Senate. The Senate or the upper house in US, they will approve the appointment of the judges in higher judiciary or Supreme Court, right? So that is what in US it is followed. Now again in US, what is the advantage and disadvantage? Advantage is that there is a appointment by the executive, just like any higher office. All the appointment is done by the executive, right? So the judges are also being appointed by the executive. There is no issues about that, because all the appointment is done by the higher appointment or constitutional appointment is done by the executive. And also in India, right, all the appointment, CAG, election commission, everybody is being appointed by the executive. Why only judges, they should be appointed by the collegium system? Or though the president appoints, but who decides? It is the collegium who decides, right, who will be appointed as the judges of Supreme Court and High Court. So such thing, it's not there in US. That is what you have to talk about. And then you can talk about the advantage and disadvantage. Advantage is that it is done by the political, just like any higher office, constitutional office, if appointed by the executive, so is the judges. Second, you can talk about the disadvantage, that there could be the chances of political interference in US, political interference, since it is done by the executive. So what is good in India? That is a disadvantage for US, and what is a disadvantage in India? It is advantage in US. That is what you can talk about. I hope you got the clarity. So the first part, I think very easy. You talk about the evolution of the collegium system, including the fourth judge case, the striking down of the NJAC, and then critically, since it is critically asking both pros and cons in India, what is the advantage and disadvantage. Similarly in US, you can talk about advantage and disadvantage, and then you can kind of conclude by that whatever the concerns regarding the appointment of judges through the collegium system, that has to be addressed. That has to be addressed, and even the Supreme Court has told that they'll bring the reforms in the collegium system to make it more transparent, to make more. This is how we can conclude the answer. The next question, question number 14, examining the evolving pattern of center-state financial relation in the context of planned development in India. How far have the recent reforms impacted the fiscal federalism in India? Again, easy question, but then of course analysis is required. So evolving pattern, you write how things have started. So just go back to the 1950s and how things have started. So, and they are asking planned development, so obviously planning commission will come. So center-state financial relation, mention article 268 to 293, part 12 of the constitution that deals with the financial relation. And then you talk about the various, the institutions, like earlier it was planning commission established for seeing that there is a planned development, and planning commission used to even allocate the resources to the states, which has resulted in some kind of concerns from the various states that it is the center who is holding the more power. Anyway, the financial relation is such, even by the constitution itself, where more power is given to the center, even in the financial matter. Even we have seen in the legislative matter, executive matter. Similarly, in the financial matter, the power is more skewed towards center. That is one thing you can talk about. The second thing you can also talk about, that whereas the more financial power is in the hand of the state, but more responsibility is in the hand of the, where the more power is in the hand of the center, financial power, right, power to collect revenue and all, it is more in the hand of the center, but whereas the responsibility is more in the hand of the states, isn't it? So that's why the financial relation is more skewed, because the more responsibility with the states, but the more financial power with the center. That is why the states are always dependent on the center, and the financial autonomy is being jeopardized of the state. So in this context, you talk about then planning commission, the resources were being transferred by the planning commission. But later on how things evolved, in then you can talk about the finance, role of finance commission, article 280. And now the financial condition of the state has definitely improved with since the 14th finance commission. The transfer of fund from 32% has gone to 42% to the state. So definitely it has improved the financial position of the state. And then of course the finance commission also gives grants, article 275 you can talk about bridging gap. Then you can also talk about article 15th finance commission, which has talked about resource transfer in the form of giving incentivizing the state. If the state is performing well, that could also be one criteria for transfer of more resources. So these are the reforms you can talk about in the terms of reforms, how article 280, role of finance commission, and particularly you can talk about since the 14th finance commission the revenue resources has increased in the shares to this towards the state 42%. And then you talk about 15th finance commission, which has been talking about incentivizing the state performance to get more funds. And then you can talk about that how PC has been replaced with Niti Aayog. Planning commission has been replaced with Niti Aayog. So earlier through the planning commission the center has more hold over the resource transfer to the state, but now Niti Aayog there is no such kind of fund transfer. It is more towards cooperative federalism and more towards policies, discussion of policies for cooperative federalism rather than resource transfer. So these are the various reforms which has come in the center state financial relation, right? So you talk about center financial relations, talk about the constitutional provisions, then talk about the planning commissions, because for the plan development we had the planning commissions. And but the planning commission, what was the one problem in the center state relation, that planning commission has a resource transfer capabilities or authority, which has resulted in confrontation among state and center. And then you talk about the reforms. In the recent year there has been reforms definitely, and in that context in the reforms part you can talk about the role of finance commission, which is a constitutional authority or constitutional body for balancing fiscal federalism. And also you talk about how planning commission has replaced with Niti Aayog. So this 2-3 factor you can talk about. This has resulted in improvement of the financial relation between center and state, and further of course further reforms need to be done, that also you can talk about. Niti Aayog definitely you can talk about cooperative federalism here. I hope you got the clarity. Simple question, very simple question. Just you have to understand each part of the question. Each part of the question you please read nicely. Center state financial relation in the context of plan development. So definitely planning commission has to be mentioned here. And then how far recent reforms impacted the fiscal federalism, and in that you talk about 14th finance commission, 15th finance commission, and also Niti Aayog. Look at the next question, number 15. What are environmental pressure groups? What are environmental pressure groups? Discuss their role in raising awareness, influencing policies, and advocating environmental protection in India. So there is a pressure group, right? But they had asked particularly about environmental pressure group, and of course, you know, nowadays this environment issues has been become a hot topic everywhere. We are talking about because of the very serious issues of climate change and all. So environmental pressure groups nowadays, they are in the too much in the limelight because of the very high concerning issues of climate change. So in this context, you talked about what is pressure group. You can talk about, define the pressure group, and then particularly the environment pressure group, discuss their role in raising awareness. So any pressure group, what they do, they are being formed with certain objectives, so their objective is to protect the environment, making people aware of the policies of the government, or the industries, or so how they are harmful for the environment. So not only the policy of the government, but also various industries, the way they are functioning, they are polluting the environment, cutting down of these trees, deforestation, all these things in the name of development, how we are harming the environment. All those things you can talk about. Because of the environmental pressure group, only this Environment Protection Act has come into being in India. And you can mention some environmental groups like pressure group like Greenpeace. You can mention about Narmada Bachao Andolan. You can Chipko movement. All these things you can little bit talk about, and how they have resulted in a influencing the policies of the government towards sustainable development or protecting the environment. So they create awareness among people. They also influence the policy of the government towards protecting the environment. That is what you have to talk about in this question, influencing the policy and advocating the environmental protection. And this some NGOs or some pressure group environmental like Narmada Bachao Andolan, Chipko movement, we can talk about against deforestation and or against displacement, Narmada Bachao Andolan, Greenpeace. Yes. Look at the next question, number 16. Inequality in the ownership pattern of resources is one of the major cause of poverty. Discuss in the context of paradox of poverty. So here you talk about inequality. I think the first part of the question is very easy. I think you will be able to understand very well. Inequality in the ownership. So yes, in India we know, you can quote Oxfam report in which it says that 5% of Indians, they have 60% of the resources, and bottom 50% of Indians, they have just 3% of the resources. So you can quote any the report or so to justify your answer that yes, this is what, there is a huge inequality in India. To emphasize, you can quote any report, and which goes against the constitutional norms of Article 39B and C. Article 39B and C talks about what? Prevention of concentration of wealth in few hands, isn't it? That the resources of the country should be distributed in such a manner to serve the common good, and there should be prevention of wealth in few hands. So that is what Article 39B and C talks about. That is what the objective of the Constitution, to create an egalitarian society. But what is the reality? The reality is very, very different, where there is a high inequality. What is paradox of poverty? Paradox of poverty means poverty amidst plenty. Poverty amidst plenty. So in India is blessed with resources, isn't it? All type of resources, natural, material, minerals, all type of resources, agriculture, we are blessed with. So there should not be a system of such kind of very, very high, you can say, destructive inequality, destructive inequality. So it is poverty amidst plenty. We have enough, but the problem is what? There is lack of distributive justice, lack of distributive justice. There is no proper distribution, there is no proper distribution. So that is what we have to keep in mind, Article 39B and C. So inequality in the ownership pattern resources is one of the major cause of poverty, right? So right, with this we can very easily say, right, 5% of individual in India, just they have 60% of country's resources, and bottom 50% of the people in India, they have just 3% of the resources. So obviously this report itself showcase the kind of inequality we have, and that is what there is a paradox of poverty. We have enough of resources. If there is a proper distribution of resources, definitely there will not be such a kind of poverty in India or inequality. So this is how you can quote the examples, and then you can talk about what the government's solution. You can write about the government schemes and policy regarding progressive taxation. You can talk about wealth tax, you can talk about mudra scheme, access to credit and all. So slowly Jan Dhan Yojana. So inclusive development, basically inclusive development. Talk about you can talk about this inclusive development, and what are the various government policies and schemes which are which will take India towards inclusive development. That is what you have to talk about. The next question, number 17. So in the contemporary development models, decision making and problem solving responsibility are not located close to the source of information and execution, defeating the objectives of development. Critically evaluate. Now this question you have to understand well. Actually this is an easy question, but then you need to understand very well. The question is talking about that decision making and problem solving responsibility are not located close to the source of information. What does it mean? It means that we have a centralized development mechanism rather than decentralized. That is what the theme of the question. If you understand the theme of the question, you can very easily handle. So we have a more top-down approach, but then what we should go for? Bottom-up approach. Because if the development is, the issues of development or the plan of development is, it is being formulated at the top level, they may not have the real idea of the local reality, isn't it? So obviously we may not come up with the proper policies or need-based policies. For need-based policy or proper policy, what is important? That the policy should come in consultation with the affected stakeholders. All the stakeholders should be involved in the policy making stage also, not only at the implementation but policy making stage also. So yes, in India the policy making is highly bureaucratic and highly centralized, and that is what the major problem, why the policy is not being translated into effective implementation, or why the policy does not results in the proper results which it intends to achieve, right? Why it is not properly achieved, the goals, why they are not properly achieved? Because too much of centralization and a bureaucratic approach to the policy making. Then what is the solution? Of course the solution is bottom up approach. You have to, in this context, you talk about article the 73rd and 74th Amendment Act and decentralization, democratic decentralization. That is what we have to take. The developmental models, the decision making should be close to where it has to be applied. Policy making and implementation both should come in consultation with the affected stakeholder. It should be participatory developmental model. Participatory developmental model. That is what you have to talk about. The next question you see, question number 18. The National Commission for the Protection of Child Rights has to address the challenges faced by children in the digital era, examine the existing policies and suggest measures the Commission can initiate to tackle the issue. So here you have to talk about the National Commission for Protection of Child Rights, which came into being in 2005 for safeguarding the interest of children, safeguarding and providing protection to the children, right? That was with that objectives we came with the National Commission for the Protection of Child Rights. Has to address the challenges faced by children. Now then you talk about the second part of the question. You talk about what are the digital, because of the digital era, what are the challenges faced by the children? So in that you can talk about cyberbullying, child pornography, games addiction, right? Cyberbullying, child pornography, game addiction, all these things, these are the problems, right, faced by the children. Then examine the existing policies and suggest the measures. Then what are the existing policies? So of course you should know what are the existing policy. In this you can talk about the Information Technology Act that prevents child pornography, or try to provide the regulations of the digital platform that are harmful to the children. Harmful content, digital harmful content also you can write, digital harmful content for the children, that is also an issue. And that is what the IT Act 2000 they have tried to solve. And in that again another act you can mention about another provision, what CERT in you can mention, Computer Emergency Response Team India, how they help. Then you can also talk about the POSCO Act, which is against sexual content for the children or sexual offense against the children, which is done in the digital platform. So all these things, 2 or 3 you can talk about what you remember, and then suggest measures for the commissions that can initiate. So what suggestion will you provide? In that suggestion you can talk about that children, parents, teachers, they should be provided with the proper guidelines. The commission should create an awareness among children, teachers and parents, because they are the one who are being intimately connected with the children regarding the harmfulness of the various digital kind of things. Then you talk about creating awareness, creating regulations, creating awareness, creating more stringent regulation, creating more legal framework, stringent punishment for the violation of such kind of act. So these are what suggestion you can suggest to the commission to protect the children against abusive digital content or problematic digital content. I hope you got an idea. You talk about National Commission of Protection of Child Rights 2005, why it has come into being to protect it has a mandate protecting children's rights or safeguard their rights. And then you talk about what are the problems or challenges faced by the children in the digital era, which we have talked about: cyberbullying, child pornography, game addiction, harmful digital content, all these things you talk about. Then you talk about what are the existing policies, in which you talk about IT Act 2000, CERTIN and POSCO Act. And then you can talk about what are the suggestions for the commission, so that the children can be particularly protected against abusive or problematic digital content. Question number 19. Energy security constitutes the dominant kingpin of India's foreign policy, energy security, and is linked with India's overarching influence in Middle Eastern countries. How would you integrate energy security with India's foreign policy trajectories in the coming years? So again, this question is also not much difficult. I guess it is easy only. You can say that 80% of our oil or energy requirement is fulfilled by importing, right? So we are dependent on other country for energy securities. We are not self-sufficient in this context. In fact, 80%, which is a major aspect of the energy security, we are dependent on other countries. And mostly and traditionally, of course, the Middle East, because Middle East is the rich source of the oil and the energy requirement for India. And that is how our relations with the Middle East countries, Saudi Arabia, UAE, Iran, Iraq, Qatar, all these are our engagement with this country. It is more influenced by because of our energy security. Of course, we have a very high number of diaspora there, and also because of the energy security, our engagement is kind of influenced because of the energy security of India. That is what you talk about. So any issues, and you know how the Middle East countries are, most of the time there is lot of instability. One or the other way, the region has been unstable. Currently also Israel-Palestine war, and the Iran-US skirmishes. So there has been, almost all the time there is some issues, or there is an instability. So we can't keep on depending, and we have already seen in the 90s the oil crisis, and then 1970s also there is a oil crisis. The oil prices shot up very, very high because of instability in the Middle East. So what we need to do? We need to diversify. We need to diversify our energy fulfillment. For that we need to diversify. So of course we are moving towards Africa. We are importing the oil requirements and energy requirement from Africa. Also Russia, hugely nowadays. In fact, Russia is a major supply for us in terms of oil requirements or energy requirements. So in that way we can say that we need to diversify. There is one thing, diversification, and also we have to explore in India itself. We have to explore the region in India which are oil bearing, or which we can secure in India itself, India. So more exploration has to be done in India. One, diversification in the countries, Africa, Russia you can mention. In India you can mention about more exploration has to be done in terms of fossil fuel, and also diversification in terms of renewable energy. Renewable energy, one we can mention that, renewable energy. So not only fossil fuel, but also we should move towards renewable and clean energy. Anyway, all the countries of the world, they are moving towards renewable energy, and so the India also. We have, and talk about the government policies and all. We want to go for zero emission by 2070, and for that renewable energy is very, very important, extremely important. And you can talk about International Solar Alliance also. That is how we are giving a lot of importance to the renewable energy. So that is what you can talk about. That is what saying India's foreign policy trajectory in the coming years in terms of energy security. So one, you can talk about the diversification, and one, in India only, the one we need to explore more for the energy security, and secondly also for we should go for more renewable source of energy, which is India is a very rich in terms of renewable source of energy, solar energy, wind energy, all kind of energy. We are very much rich. We just have to tap it. We just have to tap it. That is what you have to talk about. I guess it's clear. Easy question. I think it's an easy question. The last question. The reform process in United Nations, the reform process Yes, the reform process in the United Nations remains unresolved because of the delicate imbalance of East and West and entanglement of the USA versus Russo-Chinese alliance. Examine and critically evaluate East-West policy. Confrontation in this regard. So here it is about United Nations reforms, which India has always been so much giving kind of focus for UN reforms. We are aspiring for permanent seat in UN Security Council. So the UN order should reflect the current reality. India being the most populous country, and also the way India is an highly performing emerging market economies, India's contribution towards the world economy in terms of population, in terms of economy, definitely it has to reflect the present order in United Nations as well. So we have been aspiring for permanent seat, but because of the various reasons, it has still been unresolved. It has been resolved. So you can talk about United Nations and United Nation Permanent Security Council, where India is aspiring along with the G4 countries. Then why still it has not been resolved? Because of East-West problem, whereas the US has its own issue, because now you know there is a P5, the veto, and because of this veto by the P5, one or the other member, the reform is not able to take place. So sometime it is US and sometime it is the Russia and China, they are obstructing. Particularly in case of India, if you have to talk about, it is the China factor. So China is obstructing Japan and India from getting the permanent veto power, because obviously they don't like, they feel that their national interest would be compromised if India and Japan become the part of permanent Security Council. Similarly, US has also been obstructing to some, because they feel their national interest would be compromised, because they will align with the people, or they will support such country to become part of United Nations Security Council who align with the US goal, right? So US has its own issues, and Russia and China has its own issues. Because of the East and West problem, there has been a lot of issue, and UN issues has still not been resolved, because there is a this P5 people, they have to come to a consensus before there is the reforms is brought in the United Nations Security Council or United Nations as a whole. The P5 has to agree, there has to be consensus, and that is what it is not happening, and because of that it has not been resolved. So in that context you can talk about United Nations, mention about the G4, and the current reality must reflect in the United Nations Security Council, and for that it is very, very important that the reforms need to be brought. And then you talk about what the US has a problem, and then Russia, China has a problem, and because of that they are not coming together and the reforms is being obstructed. I hope we have completed all the 20 questions. We have not gone into very much detail, but then I have tried to give you a certain idea that how these questions could have been attempted or how these questions could be tackled. And with this, I feel this session would have been very useful to you. You will take cue from this session to understand the meaning of the question and also how this question could be approached. Thank you. All the very best. We'll come with the discussion on GS paper 3 and GS paper 4 as well. Thank you. All the very best.